All right, welcome back to the channel where we empower you with real law, real remedy, and real results. I'd like to thank everybody for making it back, and for you guys who are subscribed to the channel, I appreciate you. Some of the new people being subscribed, I appreciate you, and I appreciate you guys enjoying this content, and I just want to bring better content for you. So, today we're going to be answering some questions. Can a child support agency force me to pay in cash for my bank account? And the real answer is basically not lawfully. Now, we have to understand legally they can, but lawfully they may not have a right. So to be honest, legal and lawful are they're infused, because if something is not lawful, it's technically not legal. But since they can do it legally, there's kind of air quotes, they'll try to do it. Okay, so you have to always know your rights, because if you don't know your rights, how can you enforce them? Okay, not unless they show an actual loss. So in the video, what we're going to do is we're going to show you how to challenge cash demands legally, how to expose unjust enrichment, use tender, equity, and UCC protections to defend your estate. So that's one thing most people have to understand. When you're going to court, you're dealing with estates, you're dealing with property, which can be considered real property. So you really want to tune in, and because we're going to go deep today. So most people believe if the court says pay, you pay in cash. But here's what they never told you. Courts and agencies get paid by federal programs. Most of them didn't spend money to create your debt. So what are they being paid back for? If they didn't lose anything, their cash demand isn't restitution, it's revenue. That's not justice, that's unjust enrichment. Here's how you challenge a cash demand lawfully, step by step. Step 1, affirm there is no legal requirement to pay in cash. I am not aware of any statute that mandates cash payment for this obligation. Please cite specific law that overrides 31 USC subsection 5103, which allows lawful tender in multiple forms. So you may have heard this. This is what HJR 192 was basically codified and placed into 31 USC subsection 5103. Now, a lot of people may not agree with me, but a lot of people found my video when I was talking about HJR 192 not really discharging your debts to be kind of jarring, because you hear this from everybody. They always tell you HJR 192 discharge your debts. People have to understand that the Negotiable Instrument Act of the 1800s came way before HJR 192. All HJR 192 did is make it so there could not be a gold clause in an agreement. So you can't have a clause in agreement that requires one specific form of currency. So if you really want a deep and insightful overview of that, you might want to go back to my video where I'm talking about HJR 192 doesn't discharge your debts. Okay, step 2, tender a lawful instrument. The reason why you have the ability to do this is court is nothing more than paper. Okay, you can't demand me to do something you're not doing. And if you demand me to do something you're not doing, that's what's called unjust enrichment under law. Okay, I've tendered lawful value in the form of a pay order, promissory note, credit offset, special deposit, etc. Under UCC subsection 3-603, this discharges the obligation unless refused for cause. So you have to understand, when I'm talking about this, I'm not giving you legal advice. Okay, so I want you guys to understand you have to do your own research. You have to go and look up your statutes, your commercial code of your state, and not always use the UCC. A lot of people use the UCC, but you have to understand that some states have infused the UCC in their commercial code. So some elements of that may be missing. So make sure you tread lightly. Demand proof of a financial loss. This is one of the biggest things that most people never do. And then they go into court for mortgages. They go to court for traffic tickets. They go to court and they never ask for them to assess the damages. Where you've been damaged. They'll just tell you, oh, well, the citation, blah, 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 says we can do this. Well, hold up. That's for the executive branch. What about the judicial branch? You have to prove a loss. Okay. So please provide a general ledger or an accounting statement showing where your office or agency dispersed cash or incurred a loss related to this claim. So if many of you have watched some of my videos, I have a video, and I've done so many videos. I almost have over 300 videos on this channel. So it's very hard to remember what video I have done and haven't done. But I know if you remember one of my videos, for some of the people who are frequent viewers, where I talked about controversy. So for a court to have a controversy, they have to have an injury, meaning there has to be a balance owed, due. There has to be showing that this balance that's being held is to cover losses. If it's not, it's a revenue, so it can be challenged. 4, you want to assert your fiduciary obligation. Okay, so if you're holding the note, or instrument, you're acting as a fiduciary. You're instructed to apply the value as the trustee for settlement. Okay, so a lot of you guys may not understand this, because sometimes it's really hard for us to just break out of this spell of thinking that we're the debtor when we get into these financial obligations, because a lot of these people are very good at slick talking and treating us like we don't have any meaning. Like, you'll file a motion in a court and then they will act like they didn't even see it. But one of the biggest things that people don't do is ensure that the motion is docketed correctly. Okay, if your motion is not docketed correctly, like if they put defendant's papers, anything, they're trying to play you. Okay, and that's probably by the judge too. The judge is trying to do that so you can't win on appeal. So assert fiduciary obligation. Okay, so remember that. Put them on notice. Failure to respond within 10 calendar days constitute as an acceptance by estoppel. Again, this is not legal advice. If you're going into court, there's some people going to court for more serious things. So in more serious things, you may want to know more procedure. Okay? So make sure that your rights are reserved. So I'm going to be clear with this. You have the right to challenge the demand for cash. You have the right to demand and challenge the demand for cash from anybody. I don't care if it's the state. I don't care if it's for taxation. I don't care if it's the IRS. You have a right to challenge. Okay? You're not refusing to pay. You're offering lawful tender. So I hate when people say this about HR 192. They stole your gold. How can they steal your gold? Gold was never yours. It was a commodity from the start. What was the money was the accounting of gold, the transactions. Money is created by transactions. It's not created when you leave money in an account and it just sits there. It's just sitting in an account. It's not gaining any interest. It's not doing anything unless it's in an account where it's gaining interest, which the bank is doing. But you're not privy to it. But unless they show proof of loss, disbursement, or injury, they can't force you to liquidate your estate. That's not enforcement. That's extortion under the color of law. So unjust enrichment in equity law means you received value that you didn't earn or weren't entitled to. Sounds familiar, don't it? Every time you go to court, they're trying to make you pay out something. Every time you step in court, they're trying to make you pay out something. So a person who is unjustly enriched at the expense of another is subject to liability in restitution. So if the agent gets Title 4D funding, or the court receives an administrative block grants, but still demands your cash, they're trying to double dip, and it's unlawful in equity. Let's talk about something no agency or court wants you to understand: unjust enrichment. So you really want to know this. In simple terms, unjust enrichment happens when someone demands or receives value they didn't earn. So we just talked about that. Didn't spend or weren't entitled to. And they do it at your expense. Okay? According to the restatement of third restitution subsection 1, a person who is unjustly enriched at the expense of another is subject to the liability in restitution. So I know when people hear this about court, they're like, if I bring this up in court, it's not going to work. You fight court outside of court, not in court. That doesn't mean you can't walk into court and bring up this argument, but most likely you better make sure you're on the record. And you better make sure that the docket and everything looks correct, because if not, they're going to railroad you. They're going to run over you. And judges do this all the time because they're all, let's just be honest, these lawyers are corrupt. I'm not, when you hear me say like you guys complaining, blah, 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 I'm not saying that in a negative sense. I'm saying when somebody punches you in the face, you better find out how to fight quickly. And a lot of times complaining is not the quickest way to fight. Just being smarter than them is. So you have to understand why this applies to you. So let's say the child support agency already gets paid by federal reimbursements or block grants or administrative funding, as we said. But they demand cash from your bank account. They didn't lose anything. So you have to know how to expose it. So you can demand a ledger or proof of loss. File a notice demanding full accounting. Ask, where's the disbursement you're recovering? Who did you pay? Who was harmed? These are questions that you can ask to the court or whoever's suing you. And if the court doesn't answer or doesn't allow them to answer, now you can start setting them up to knock them down like pins. Absolute immunity only protects them when they're actually discharging their jobs. So if they're doing anything outside of the Constitution, anything that could be as a private debt collection, then they do not have absolute immunity. I want y'all to know that. So you can send an affidavit or pay order. If they refuse but still demand more, that is an enrichment red flag. You can appoint them as your fiduciary. Remember, we did the video about Form 56. I said that you don't need a Form 56 to do that. All you have to do is appoint them. Under the Power of Appointment Act, you'll go read your Power of Appointment Act of your state, and you will basically confirm what I'm saying. Notify the agency that they're acting as trustee if they are holding your note or funds and don't apply them properly. That is a breach and enrichment. So I want you guys to understand this. This also applies if you lose a court case too. So if you lose a court case, you can go right back and do all of this. You really don't ever lose a court case till you give up. So you can file a judicial notice or any motion in equity if you want to. And what I found out is you can file a motion in equity in a civil or criminal case, depending on how you structure it. So I'm not giving you legal advice again, but there are ways to structure a motion to where you can file in some of these cases. So you want to make sure it's on the record. No loss, no restitution owed. Continuing to collect is unjust enrichment under equity and common law. If the state or court already got paid and they still want to drain your estate, they're not enforcing justice. They're enriching themselves. So you have to understand, let's bust the biggest myth out there. So if there is no loss, there is no lawful demand, equity blocks unjust enrichment. See, what they're trying to do is they're trying to do the legal side of things, but not the equitable side, because the legal side allows the court to get paid. So if you read Rule 1 of Federal Civil Procedures, it'll show you when law and equity infused. So in Rule 1 of Federal Civil Procedures, that is where law and equity are infusing. That was in 1937. And in Rule 2, they created a civil act. And that is law and equity being merged into one. So if you read Rule 2 of Civil Procedure, it'll show you the creation of civil law, which is law and equity being combined. So under 31 U.S.C. subsection 5103, legal tender includes coins, currency, and other forms. So you guys have to remember my HJR 1 video, HJR 192, Public Law 73-10 video, where I told you that gold was never money. It was just used as to back public and private debts. So it was a commodity to base the ledger off of. Okay, so they use gold as a commodity. And back in the days, the gold that was minted and put into circulation, that was considered like coins, like currency. So tender discharges an obligation if refused. That is UCC 3-603. The United States Constitution, section the 5th and 14th Amendment, no one can be deprived of property without due process. So what does that mean? You can make a lawful tender in other forms. They can't ignore it and demand cash without justification. They must show proof of disbursement, loss, or harm. So if you go into court, a lot of times these people will not do this. So you may have to do other actions to compel this. You can ask this in discovery. There's other things you can do to compel them to provide this information for you. You just don't have to lay down like a hurt dog hollering. So if the court is already paid, here's the kicker. Most child support and collection agencies receive federal reimbursements for every dollar collected. This is why when you go into court, they don't listen to you. You know what I'm saying? Until you set it up right, until you actually deal with them correctly, they're not going to listen to you. And the clerk is assisting the judge, who is really a clerk, not really even a judge, sitting there administratively acting as if they have the power to adjudicate a matter, which they don't even have the authority to do. So state matching funds, administrative incentive grants. That means they're not even coming out of pocket. You're being forced to pay something they already got paid for. That's a violation of equity. Ask this question. Where's the accounting showing the loss of money? You'll never get an answer because there isn't one. So someone cannot force you to pay a debt they can't prove. So just because somebody sends you a document, you can say, okay, cool, I'll endorse it, or I'll transfer my rights to you for settlement, or I'll accept this document and you can issue a note yourself. You can do whatever you want. You run everything. So we're going to talk about some steps that can help you. Okay. I usually say when you're doing an affidavit or something, you want to make sure you have evidence or attaching the evidence to show that you attempted to discharge in good faith. Show that you already created the value. So if you had a traffic ticket, you have a notice to appear, i.e. a traffic ticket, or a child support order, and you've done all the paying and child support can't show you that they come out of pocket, then you can object to the hearing. So if they can't show you they created a value, I mean, they better find a way, because otherwise they're violating your rights, and now they all become trustees de Santoro. See another video I made a long time ago. I might have to start putting these back in the little thing, the little box. Okay, demand it be applied to the settle account. Okay, the value that you created, you can tell them where to disperse or apply it. And if not, you can default them and yada, yada, yada. So you can do a conditional acceptance. I will pay in cash upon production of the funding ledger and proof of loss. Fiduciary appointment letter. Make the agency the trustee. They must apply the value. Document your offer and apply the UCC rules. Judicial notice or motion to strike. Use equity, due process, and unjust enrichment as defenses. The fact that most of people do not know motion to strikes is one of the reasons. This is the key. Oh my God, this is the key reason that people lose their house, go to jail for child support, go to jail for all of this stuff, because they do not know how to use a motion to strike. So a lot of times the judges who we call corrupt are not actually corrupt. They're just following the legal side of the law, not the equitable side of the law. Okay. But there are corrupt judges who, no matter what you file, you'll see them changing the designation of stuff and all that. Yeah, that's a judge telling a clerk to do that. 100%. Because the judge doesn't want to be overturned. So we'll just sum this up, so I don't want to waste no more time of your life. If they didn't lose it, they can't lawfully demand it. If you tender value and they refuse it, the obligation is discharged. So a lot of times when people tender payments, etc., you don't have proof that you tendered payments. So then when the other party starts bringing a claim or they start saying you didn't pay them, you have nothing to the contrary. Remember, these people are nothing more than document custodians for you. They're nothing more than your trustees. Okay. And the reason why I'm saying this is not a presumption. It's basically off of the transaction. Just like I told you guys, if you look at the transactions on its face, if you look at a mortgage on its face, it'll show you that they never came out of pocket because there's no document. Remember, under TILA, you have to have full disclosure, which is the Truth in Lending Act. You have to have full disclosure of accounting, full disclosure of disbursements, and it has to be evident in the agreement. Anything that's not done in the agreement, the borrower or the debtor or you, which is truly the creditor, can object to. And you can challenge the whole agreement based off that. If you tender value and they refuse it, all right, I did that. So if they took federal funds and asked for more, that is unjust enrichment. So for you guys, protect yourself, protect your estate, and stop the bleeding before it starts. And if you like this content or you like my new look of my channel, just go ahead and like, comment, subscribe if this helps you. I appreciate everybody who comes in here. And I'm going to be doing some more courses, getting some more group courses on. Right now, I've just got a lot of stuff on my plate. But as usual, I always appreciate all of you. Have a great day.